Honorable Vice President, Honorable Chief Minister, Professor Thapa, Deputy Mayor Ms. Dangol, Justice Robert French, the former Chief Justice of Australia, distinguished guests, Your Excellencies, ladies and gentlemen. May I begin by thanking Kathmandu University for inviting me to this special conference that discusses federalism, devolution of power, and inclusive democracy. Since a lot of work is yet to be done to institutionalize the values of inclusive democracy in the context of federalization of the country, the discussion at this conference is very timely and topical. To my mind, deliberations to be made by eminent speakers and scholars here will benefit Nepali legal community to further shape and chart out the path that Nepali Constitution has taken in the last 8 years. As I am a practitioner of law, I'll bring to this august forum the views of a practitioner who has gained some experience in nurturing and promoting the values of inclusive democracy through case laws at the Supreme Court. Let me stress at the outset that inclusion is the signature tone of Nepali Constitution. It is the constitutional roadmap designed by our framers in the Constituent Assembly. Principally, inclusive democracy is a multidimensional concept. It is informed by the experiences of the 1990s and the first decade of the current millennium. Takis Photopoulos, a philosopher, likes to call inclusive democracy a liberatory project. It is too early, especially in the context of Nepal, to say conclusively whether it is a liberatory project or just turns out to be yet another experiment that may end in failure, or a flapping of the constitutional wings in vain. This said, the impressive part of inclusive democracy are its theoretical underpinnings and their political, social, economic, cultural, and ecological ramifications. From political perspective, inclusive state rejects the capture of state power by a handful of elites who secure more votes in periodic elections. In that sense, it does not accept the electoral winner taking everything and the loser losing perennially. Nor does it accept equality and non-discrimination being considered only an act of going to the polling booth and casting votes. We have tried to introduce inclusive democracy in the political process by incorporating proportional representation and inclusion in vital institutions of the state. There are social, economic, and cultural dimensions as well. And what impresses me more is the ecological dimension. Environmentally, inclusive democracy doesn't allow the state to remain oblivious to the environmental challenges and climatic devastation for short-term economic interest and benefit, especially when it comes at the expense of environmental damage and devastation. Rejecting the archaic notion of parens patriae, inclusive democracy calls the state to act as trustee of the nature and work for realizing ecologically sustainable development. This is the expression used in our Constitution. In a very recent decision by the Constitutional Bench of the Supreme Court, it took note of the theoretical dimension of inclusive democracy and said, and I quote, "The current Constitution firmly adheres to the notion of inclusive democracy in its preamble and provisions relating to fundamental rights and duties, directive principles, policies and obligations, and provisions relating to election and representation to the high offices at the federal, provincial, and local level. Whether or not inclusive democracy becomes a liberatory project, it echoes Photoplus and says, a liberatory project of the common populace, especially in the margin, depends on the practical application of the concept and strength of the policymakers in improving and redefining it. However, its introduction in the ground reality of Nepal has no doubt aided enthusiasm and inventiveness and promote ownership to the Constitution. After presenting my thoughts on inclusive, let me turn to federalism. From a federal perspective, the Constitution is a document that accommodates interest and aspiration of the people of various manifestation and orientation. It is done in the spirit of coexistence, cooperation, with the aim to bring about transformative change and prosperity. Nepali Constitution clearly states that the relation between the federation states and local level shall be based on principle of cooperation, coexistence, and coordination. The practical manifestation of these principles in functioning of the state is a pertinent point of inquiry. There seems to be some problems in building cooperation or accepting coexistence or reinforcing coordination. Problems have cropped up in several areas such as adjustment of public officials, the enactment of necessary laws, division of financial resources, interstate trade, and in settling political disputes through meetings of interstate councils. Constitutional and legal disputes have arisen both in horizontal and vertical relation among the organs of the state, and also regarding the role played by different office holders. Take, for example, the relation between the executive and the legislature. The Supreme Court had to grapple with the issue of dissolution of parliament twice in the same year, where it was found that the decision on dissolution was made without consulting the speaker on both the occasions. Recently again, cases were brought to the Supreme Court twice at a short interval regarding the formation of government in one of the provinces, where the role played by the governor and the speaker were put into questions. Disputes have arisen in areas such as promulgation and authentication of bills, grant of amnesties, and reduction of sentences, and the like. Regarding vertical relation among federal units, disputes have been brought to the Supreme Court on a number of issues, such as determination of the boundaries of the local bodies, fixing and shifting of the headquarters of the districts, etc. Disputes have also arisen due to the overlapping of annexes that base legislative power to different federal units in a number of areas, such as levying tax on natural resources, establishment and running of schools. There has been a big problem on the enactment and running of the schools at the local level. Utilization of water resources, protection of forest, land and water resources, environmental and climate change concerns, and operation of institutions such as water user groups or community forest user groups, etc. Some of these issues are quite serious, requiring immediate intervention through interim orders. Federalism, to my mind, is not a system that imposes multiple shackles. Rather, it is a system of self-rule and shared rule. Apparently, there are teething problems on both of these scores. Hopefully, many of the disputes that I raised will be resolved, and the judiciary will be able to play a meaningful role in setting out both niti and nyaya, interested to it, by the Constitution. Finally, since we are discussing Constitution, let me share my thoughts about the Constitution itself. There are several reasons for the people attaching so much importance to the Constitution. First, the Constitution is important because of its normative values and for embodying rights. For me, the Constitution is important because of its democratic credential. If the Constitution or our actions under the Constitution do not resonate to democratic ideals that it espouses, it ultimately turns out to be a facade for governance. Secondly, the Constitution is important because it lays down national goals and future direction of the country. Even though there are views which consider Constitution as a colorless document, a more prevalent view is to treat it as a document of social economic transformation. Thirdly, the Constitution is important because of the discursive space it gives to the community as a collectivity and to civil society organization in policy formulation and implementation. Finally, some even like to take it to the extreme and term the Constitution as a scripture. I would not go to that extreme and instead emphasize on the need to adopt flexibility. This said, even if one takes the Constitution as a scripture, this scripture should nurture the institution we call democracy, or rather inclusive democracy. Institutions, to my mind, are not abstract entities. They are beings which should give fuel to society for sustenance and prosperity and help in navigating transformative potential of the Constitution. I end by quoting Granville Austin, who said, "It seems that human beings construct temples called democracies, but then pay insufficient attention to those who become the clergy. Time has come for all of us to reject and say goodbye to the clergy who, rather than caring for the temple, contributes to its corrosion by indulging in self-serving projects." I thank you for your kind attention and wish good luck for the success of the conference. Thank you.